So within the probate space, we have a couple special circumstances that include conservatorships, which is an important area. And many attorneys that do estate planning or probate do not do conservatorships and refer out to a expert in that field. Really lucky today to have somebody who is such an expert, as well as does other forms of trust and probate litigation. Tamiel Hollaway from the law firm of Hollaway and Kimberlin. Tamiel, thank you for taking time with us today.
Oh, happy to be here. Thank you for the invite.
How did you get into the niche of conservatorships?
Truthfully, I come from a couple of attorneys. My father, my late father, had a pretty thriving probate practice, and I fell into it just working with him and watching him my whole life. Always working with like seniors and in the conservatorship and wills and trust and estate space.
My father's attorney as well, and I stayed the heck out of law.
You were smarter than
He didn't like how law changed. I think he was old school and was very service oriented. And I think he felt the business became too cutthroat and too focused. And I think, you know, you happen to hit a niche where you really have to be very concerned with helping your customers. You must, I would imagine, have to lead with your heart if you're going to be in conservatorships as an attorney.
Mm-hmm. I agree. I think like now that the housing prices have increased and there's so much money floating around Los Angeles, I think a lot of people have lost sight of like what's in the best interest of people who are facing like dementia or some kind of developmental challenge. And it's just kind of turned a lot into like people fighting over a pot of money.
I used to go to court all the time before COVID. And that's exactly what it was. I felt like it was kind of like those, I've never been to one, but like in the movies, they have those cockfights where they take the chickens or the roosters and they push them at each other and they let them go. And I felt like they're kind of doing that with the parties. And it just seemed that it was very intense, very, not much focused on the individual person. And at the end of the day, you have somebody who's in such a difficult position, they need a conservatorship. Like that's, at the end of the day, it's never a good thing.
No. And I think also like with the changes in the law, now that we've had like the Britney Spears event, there's a lot less focus on best interest. And I think it's the advocacy piece of making sure that everyone's heard, whether or not they have a disability, is important. But I think it's kind of being manipulated, and that now people are coming in and taking advantage of people who really need services. And I think judges are a little bit more hesitant to make decisions about what's in someone's best interest. It's like, that's why we have judges, because someone has to make the call. Can this person make that decision or not? And I think like now with Britney, it's more of a dance than it is anything actually getting done.
Well, you know, it's a tough situation because on one hand, you see somebody who I'm not speaking about Britney, but in general, you see somebody who doesn't have the capacity to manage themselves. On the other hand, you can imagine families pressuring and taking away people's rights. That the bar should be high. You should have to prove a lot. You should have to make it obvious. And I'm not saying in Britney's case, I don't know anything about the case, other than whenever there was a hearing, there was like a protest outside.
Yes, there was a lot of protesting.
Other than that, I can't say I have an experience with it, but I would say it should be a high standard. You shouldn't be able to take somebody's rights away without, you know, serious legal proof and procedures, right? But that's expensive. Yeah. That process is cumbersome.
Agreed. And I mean, the mental health space is even more restrictive. Like annually, the conservatee has a right to petition for a trial or a jury trial and get off conservatorship, because in the mental health space, we're actually like locking people up and forcing them to take psychotropic medication, which is, you know, a big deal. So people should have a right to challenge that. But the problem is just that now we've like allowed you know, less than scrupulous private attorneys to come in when people aren't actually maybe being taken advantage of, to just try to like, you know, bleed the estate by causing like frivolous litigation or trying to navigate that person into the hands of somebody who actually is trying to, you know, steal their funds, essentially.
Now, are there ways to avoid conservatorship with proper estate planning? Can the assets be managed and decisions made without, or is that still creating a conservatorship through the estate plan?
Yes, there are ways. Obviously, like you said, if you create like a trust or if you even do basic estate planning, just create a power of attorney, that would help you maybe avoid a conservatorship. But essentially, like it's a little hard because the conservatorship may not be 100% up to you. It might be that another family member isn't happy with your choice of power of attorney or trustee, or doesn't think that person has your best interest at heart and challenges that document. So you might find yourself in the conservatorship space despite your best efforts.
I don't know if you noticed in the news last week was Jay Leno, who was petitioning for conservatorship for his wife. And I don't know, to me, it just seems like with all the money he's made, with all the attorneys over his career he must have paid, they didn't have some way of planning ahead to avoid going through a public conservatorship. To me, there must have been something missed along the way. Am I missing something, or is that obvious?
No, I agree with you. There must have been something that he was trying to do, or some roadblock that he ran into in maybe trying to manage her care or her health. And someone said, I don't feel comfortable resting on whatever document you have. You need to get a conservatorship. And I'll be perfectly honest with you. There are a lot of people who are afraid to face their own mortality and do not estate plan despite the number of assets they have. So it's possible that like maybe she just refused, like because she didn't want to deal with it. And here we are.
So now I know you do conservatorships and litigation. Do you do estate planning as well, or is that something that you let other people do and you're more the cleanup when things are done properly?
I let other people do it. I used to, when I first started practicing, do some estate planning, but I just found that I think people just change their minds a lot. I personally just find it, I don't think I have the patience to walk with people on that journey of changing their minds about how they want things to go and who they want to include. So it's just easier for me to kind of come in on the back end and kind of help. I'm a little bit more of the sheriff's in town, let's clean this up kind of situation, as opposed to like, let's plan ahead.
It seems like it's a different personality. I literally interviewed an attorney yesterday who does estate planning, and what I like about them is they follow up and follow up and follow up, because so many people will meet with the estate planning attorney, they'll get the documents, but they won't fill them out, they won't record them, and of course it's of limited value if you don't do all the work, and yet they have systems set up, and she has the heart to follow up on that. Most attorneys look themselves as attorneys, not as babysitters. And I think there's a little bit of babysitting you have to do in any sales business to get people to finish the job. In your case, it's more straight law where you're more litigating. So are you brought in then by private parties who want to establish conservatorships? Do you work as a public conservator, or how does your role fit in the business?
So private parties come to me with litigation, and then also I do court-appointed work. So I'm on different lists for the court. So if they need someone to step in, either as like a neutral, so I act as a guardian ad litem in certain situations when they need someone to make a call on best interest. And then they also appoint me as court-appointed counsel, where I go in and I advocate for the person who needs to be conserved and provide them with counsel, essentially. So I do it both ways. And it's good because you get a different perspective from a court appointment as opposed to a private conservatorship.
It would seem very different. And then, but also it gives you a chance to work with the different attorneys, see both sides of the issue, see what works and doesn't work from both sides of the table. So I imagine that'd be real positive. I imagine when people come to you and say, hey, I have a problem with my wife, my spouse, my this, we need to put together a conservatorship as a private, it's got to be an expensive process. What do you tell them up front? Do you give them, are you able to quote a figure? Because I know it also depends on ongoing court hearings. There's no way to really predict all that. So how do you counsel people come to you up front who want to establish a conservatorship?
Well, usually I'll tell people, even the filing fees are like $435 like a petition, or $1,000 if you want to file for a conservatorship. So, I mean, the bottom line is I tell people, like, up front, you need to at least have funds for cost, and you need to at least be realistic about the initial petition filing. So, you try to get some money up front. And usually I counsel people to say, like, if you're successful with this petition, 9 times out of 10, the court is going to, reimburse you from that subject person's estate. So if that person has funds, then there's money, to reimburse yourself and to make sure that you're going to be made whole. If that person doesn't have funds, I have to tell people, like, you might be in for a big fight, and, you have to really check your finances to make sure that you're ready to go down this road, because there's no pot of money to like recover from.
Now, I know also in that field, there are the objectors and litigants who see a conservatorship being petitioned and say, no, I don't want my mom, dad, whatever in it, or I don't want so-and-so involved in the process. Do you also take on those cases as objectors or other interested parties as an attorney?
Yes. So I've represented I've represented conservatees, I've represented conservators and objectors. So I've seen it from all perspectives. I mean, when I take on a client, I just try to make sure that I feel like, for me personally, that person is on the right side of the law and on the right side of morality. Like, are we doing this for the right reasons, or are we just doing this to be obstructionists? I'm not interested in like clogging the courts with less than meritorious petitions. So
Now, I know in many cases in conservatorships, the conservatee isn't able to, they're maybe not ambulatory, maybe they're, have medical situations or mental situations that might make it difficult for them to come to offices, come to court. I know there's different options, procedures for court and all. How do you handle that personally as an attorney? Do you do video? Do you need to see the conservatee in person one time, several times? How does that work?
well, thank God for video, right? I mean, I
Oh my
can
gosh, yes.
I can FaceTime with people. I can, Zoom. I have every video app on my phone and on my computer. So if it's a situation where like I really genuinely feel like, there's a decent caregiver in place, there's no elder abuse, I can set up a video call to check in with people and feel comfortable with that, to, make sure that their living space is up to snuff and they have the things that they need. And if I had to meet with people privately, I could go in person and do it. And if for some reason I'm traveling or I can't get there, I can send like a paralegal to set up a video to talk to my client privately. So thank God for video. And then I also go to people, and believe it or not, there are transportation specialists in the great city of Los Angeles who just specialize in, transporting people with dementia and transporting people with developmental issues. So I engage those people when I need to have that person in court or I need to have that person in the office.
Well, I think that's the difference between somebody who specializes in this and somebody who dabbles in it, because when you specialize in it, you've got the different vendors and services available that the part-time person fumbling through it just doesn't even know exists. So I've talked to several other attorneys on conservatorships, not even mentioned there was such a vendor. It's really fascinating to hear. I really appreciate that. So Tamiel, obviously this is a personal relationship and somebody engages an attorney for conservatorship much more so than other forms of law. If somebody who's interested in talking to you about representing them either as a conservator, objector, what's the best next step for them to get in contact with you?
I'll phone 213-272-1000 or email. I always have a phone with me. So I would say email, and we also have a website, hollowayandkimberlin.com.
Fantastic. I'll put that information in the description down below. Really appreciate your time. Thank you so much for educating us. I really appreciate it.
Thank you. Have a great one.